Welcome back to the Deep Dive. Today, our mission is to cut through all the complexity of some really high-stakes clinical scenarios. We want to give you the absolute core actionable knowledge you need, especially if you're in the middle of prepping for your situational judgment test.
Right.
So today, we are deep diving into one of the most ethically challenging and, frankly, highest frequency topics, not just in the MSRA, but in clinical practice itself. End-of-life decision-making.
It comes up all the time.
It does. And we're going to focus specifically on DNACPR do not attempt cardiopulmonary resuscitation and how the law really mandates the use of things like advanced directives and the Mental Capacity Act.
Yeah, the legal side is crucial.
So we're going to be synthesizing the GMC guidance, anchoring ourselves in some landmark case law. You might have heard of Tracey and Winspear, and really decoding what the SJT rewards.
So what a safe doctor does.
Exactly. What gets the high score versus what's a tempting but dangerous shortcut. So let's just unpack this with a pretty stressful dilemma. Picture this. You're covering a general medical ward, it's late, and you come across an 84-year-old patient. She has advanced end-stage COPD. She's septic, confused, and, well, clearly lacking capacity to make decisions.
It's a very common scenario.
And you're looking at the transfer paperwork from her care home, and you find a note. It's just stamped on the page. It simply says, DNACPR for all residents.
Oh, wow.
The tension is immediate. You know this isn't right, but what do you do first? What does the law actually demand from you in that moment?
Well, the core truth for the SJT here, the thing to hold on to, is that lawful, safe end-of-life decision-making is a balancing act. It has to.
A balancing act between what?
Between your clinical judgment, is CPR actually going to work here?
Yeah.
And the person's own values, plus the strict requirements of the law.
Okay.
So the best answers, the highest scoring ones, always involve individualized planning and just crystal clear documentation.
Right, so no shortcuts.
No shortcuts. And you can see why this topic is consistently rated moderate to hard in the exam. It tests all the fundamental GMC duties at once.
Like what?
Involving patients early, being honest about outcomes, and, crucially, acting lawfully under the Mental Capacity Act. The trap answers, the ones that score terribly, almost always lead you towards unlawful or discriminatory care.
Which the SJT punishes severely.
Exactly.
That sets the scene really well. We need to be surgical with our definitions here because confusion leads to, well, clinical and legal disaster.
Absolutely.
So let's start with the biggest misconception, the precise scope of a DNACPR order.
Yes. It's fascinating how often this is misunderstood, even by experienced staff. So we have to get this clear. DNACPR is about CPR only.
Only CPR?
Strictly. It's an order not to attempt chest compressions, not to attempt defibrillation. That's it.
So it's not a sort of general stop treating order?
No, absolutely not. It is not a blanket do not treat order. The safest doctor, the one who scores highest, immediately clarifies this to the whole team and to the family.
So what does that mean in practice? What continues?
All other appropriate care. So that could be intensive treatment like antibiotics, oxygen, fluids, good pain relief. It might even mean escalation to a critical care unit if that's appropriate.
So you could have a DNACPR and still be on ITU?
You could. Preventing that slide into undertreatment, what's sometimes called therapeutic nihilism, that's a key feature of a safe choice in the SJT. If you see an answer that says DNACPR means comfort care only, that's almost certainly a trap.
That distinction is incredibly important. So once we're clear on the clinical scope, we need to look at the legal framework for patients who lack capacity. This is where advanced directives come in.
Yes.
Which documents actually have legal weight?
When capacity is gone, we turn to the lawful instruments. The first one is the ADRT. That's the advanced decision to refuse treatment.
And that's legally binding.
It is, and this is a big if it's valid and applicable, but the law sets a very high bar for it, especially if it involves refusing life-sustaining treatment.
What exactly is that high bar then? Can I just say to my doctor, I wouldn't want CPR, and that's it, it's binding forever?
No, absolutely not for life-sustaining decisions.
Yeah.
For that, the ADRT has to be in writing. It has to be signed by the patient. It has to be signed by a witness, and it must explicitly state that the decision applies even if life is at risk.
So it has to be very clear.
Crystal clear. If any of those formalities are missing, it's still really helpful information about their wishes. But it is not legally binding. It doesn't just override your duty to act in their best clinical interests.
Okay, so that's the ADRT. What's the other instrument?
The second one is the LPA, the lasting power of attorney for health and welfare. They essentially step into the patient's shoes. They act in the patient's best interests when capacity is gone. But And this is a critical clinical detail. The LPA's authority is limited by clinical appropriateness.
So if an LPA demands a treatment that we as clinicians know is completely futile,
Right.
say asking for dialysis in a patient with multi-organ failure where there's just no hope, we don't have to follow that.
Precisely. They have the legal authority to agree to or refuse appropriate treatment, but they can't demand clinically inappropriate or futile treatment. Our job is to respect their authority, but our clinical judgment on futility is paramount.
Right, so let's go back to our scenario. The patient is septic, lacks capacity, and we can't find a binding ADRT or an LPA. This is a best interest decision then.
It is, governed by the Mental Capacity Act.
What's our primary duty before we make that DNACPR decision?
Consultation. Your
Yeah.
primary duty is consultation. You have to apply the full MCA best interests checklist,
Yeah.
considering past wishes, values, all the clinical factors.
And this is where the case law comes in.
Yes, this is what cases like Tracey and Winspear really cemented into law. You have a profound duty to consult the patient if they have capacity, and if they don't, you must consult those close to them, family, partners, carers.
That sounds very black and white, but what about in a real crisis? Like our septic patient. Minutes count, maybe the family is unreachable. Does the MCA really expect us to wait?
That is the essential friction the SJT is testing. The duty to consult is almost absolute, but the law does recognize exceptions. But only when consultation would cause documented harm or if it is genuinely impracticable.
And impracticable means?
It means the delay would actively compromise the patient's immediate safety. And if you do proceed without consulting, you have to document exactly why that duty was suspended. And then you must consult retrospectively as soon as you can.
So a unilateral decision without a very good documented reason is going to score badly.
Very, very poorly.
That's a powerful framework. Okay, let's pivot to application. We have the principles. What's the clearest, high-yield, step-by-step guide for action that the SJT expects?
Okay, so we need a 5-step framework, something that moves you quickly from understanding the person to implementing the legal safety net.
A clinical and legal sequence.
Exactly. So step 1, explore values and goals. Even if capacity is fluctuating, you review old notes, you talk to family, you try to understand the patient's goals and fears. And critically, you have to explain the realistic outcomes of CPR for them. This isn't about forcing a decision, it's about building a shared understanding.
Okay, that's step good.
Step 2, check legal documents immediately. Check the medical records for a valid, applicable ADRT or an LPA. Respecting lawful authority is non-negotiable.
Right. And step 3.
Step 3, clarify scope. You immediately clarify to the team and to the family that the DNACPR is CPR only. This prevents that dangerous do not treat error. It ensures all other appropriate care continues.
Step 4 must be the MCA.
You got it. Step 4, apply MCA best interests. If capacity is lacking and there are no binding documents, you use the full MCA framework. And that absolutely includes the duty to consult unless it's genuinely impracticable.
And finally,
Step 5, document and review. Document everything, the whole discussion, who was consulted, the rationale for the decision, and crucially, set specific triggers for when the decision must be reviewed. A change in clinical status, for example.
that stepwise approach seems essential for safety, especially under pressure. But how do we lock those 5 steps into memory when the adrenaline is high? We need a mnemonic.
Of course. We can use CALMR. It's designed to be simple.
Kill him. Okay, break it down for me.
So C is for capacity and values, exploring their wishes. A is for the ADRT LPA, check.
Checking the legal docs.
Yep. L is for limit DNA CPR to CPR only, clarifying the scope. M is for MCA best interests, so the consultation and the rationale. And finally, R is for record and review, CALMR.
I think it's worth just pausing here for a second. We're talking about scoring high on an exam, but these decisions are so profoundly human.
They really are.
And the fact that the GMC focuses so heavily on that consultation duty, on explaining realistic outcomes,
Yeah.
it shows the real skill isn't just knowing the law. It's having the compassion to deliver bad news safely and respectfully.
Absolutely. The memory hook we use to anchor this is a visual one. I want you to picture a respect plan icon. You see how the circle for CPR is distinctly separate from all the other boxes of care?
Ah, I see that. Yeah.
That visual separation symbolizes that core distinction. DNA CPR does not equal DNT, do not treat. And honestly, that single concept is probably the highest scoring nugget in this whole topic area.
Let's test this framework against some typical MSRA patterns, starting with the one we opened with. the blanket DNA CPR.
Right, a classic pattern. What's really being tested here is your understanding of lawfulness and the duty of individualization.
So the best action.
Hands down, you disregard the blanket note. It is legally indefensible and discriminatory. You must then immediately check for an individual ADRT or LPA, and then make a proper recorded individual MCA best interests decision.
And the trap answers lose marks because.
Because applying a blanket instruction is explicitly unlawful, according to the Resuscitation Council UK and the courts. Any option that suggests you follow that rule will drop your score severely.
Okay, second pattern. The clinician believes CPR is futile, but the patient, or maybe their family, disagrees.
A tricky one. What's being tested is your ability to balance clinical judgment against that duty to discuss and involve.
So what's the best action?
It's all about sensitive communication. You must clearly explain the very low chance of success and the potential harms of CPR to the patient or the family.
But who makes the final call?
The decision ultimately rests on the physician's clinical judgment of futility. You cannot be forced to provide treatment you deem clinically inappropriate. The key is documenting that exhaustive discussion.
So the traps here would be things like just giving in to the family, or on the other hand, just refusing to discuss it.
Correct. Ignoring their concerns or just saying, I'm writing DNR anyway, violates your duty to consult. But agreeing to perform CPR when you believe it is absolutely futile and harmful is clinically unsafe.
Let's move to the traps themselves, the answers that look quick and efficient but are actually dangerous.
The SJT loves to tempt you with these shortcuts. The first big one is any option that says DNACPR means comfort care only.
And the reasoning.
It just fundamentally misstates the legal and clinical scope. It's a CPR-only decision, and thinking otherwise leads directly to dangerous undertreatment, which is a major GMC failure.
What's another common trap?
Any option that says you should delay the discussion or wait for a senior. While you do need senior input, the duty to involve the patient in planning is continuous. In our opening scenario, delaying when the patient is deteriorating is clinically unsafe.
Right.
Third trap, avoid consulting the next of kin because they might complicate things.
That sounds tempting in a crisis.
It is, but as Tracey and Winspear established, if the patient lacks capacity, the duty to consult family is paramount, unless you can document that it would be harmful or impracticable. Avoiding them is legally indefensible.
And a final one.
This one trips people up. Suggest the patient be transferred to another team because of the ethical complexity.
Why is that wrong? It sounds like you're trying to find more expertise.
It's an inappropriate abdication of responsibility. You should absolutely escalate to your senior colleague for support, but professional abandonment of a patient is highly unprofessional and scores very poorly. You manage the complexity with supervision. You don't just pass it on.
That's a really clear distinction. Okay, let's finish with a mini rapid-fire drill using our CALMR framework just to reinforce the memory hooks.
Let's do it.
If a blanket DNA CPR is found in the notes,
You disregard it immediately, check for an individual ADRT or LPA, and then individualize the decision using the MCA framework.
if a capacitated patient asks you directly, "Doctor, should I be DNR?"
You explore their values and fears first, then explain the realistic outcomes of CPR for them, and clarify that DNA CPR is CPR only. You engage, clarify, and plan. You don't dictate.
Last one. Capacity is lacking, the patient is crashing, and no family is available.
You check the records diligently for an ADRT or LPA. Then you make an immediate recorded MCA best interest decision based on clinical judgment. And you must set an urgent review trigger documenting all your attempts to consult and why it was suspended.
Okay, we've synthesized a huge amount there. Let's boil it down to the 3 absolute essential takeaways for the exam.
First, DNA CPR is CPR only. All other appropriate care continues. That distinction is completely non-negotiable. Respect lawful authority. Check for a valid ADRT or LPA. If you don't have one, the Mental Capacity Act Best Interests Framework is your guide.
And third?
The duty to consult is almost absolute. Always involve the patient or those close to them unless you have documented clinical evidence that it is unsafe or truly impracticable to do so.
The law and the GMC guidance, they're all designed to support this kind of individualized, patient-centered care, to ensure safety and compassion even in the hardest moments. Master that CALMR framework, and you really master the ability to be a safe, compassionate, and lawful doctor.
Well said.
And if you are prepping for your SJT, you can find more high-yield resources on this and other essential topics at PassTheMSRA.com. Keep diving deep, and we'll see you on the next one.